Hi, and welcome to another WACEO coverage. My name is Asmo, and today we'll be having a closer look at some of the legal and regulatory challenges faced by PillarDAO. So, without any further ado, let's dive in. So, to start off, what is PillarDAO? Pillar itself is a multi-chain wallet operated through smart contracts, which lets its users manage various different crypto assets. In addition, Pillar issues its own PLR tokens, which grants its holders decision-making powers when it comes to funding new initiatives or deciding on the product development roadmap. According to Pillar's own website, there are currently around 22,000 PLR holders. Before diving in any deeper, let's have a look at some of the applicable legal framework and dispute resolution. So as with all DAOs, PillarDAO will generally not hold any legal personality in most jurisdictions, which makes determining the applicable legal framework they should adhere to, as well as the jurisdiction under which it operates, somewhat challenging. However, there are some commonly accepted principles related to jurisdiction which might be relevant and which we should take a closer look at. With regard to PillarDAO, these could be, for instance, the territorial principle, which is fairly straightforward. It means that the right of a state to exercise jurisdiction over matters occurring in its own territory. We also have the active personality principle, which is the right of a state to exercise jurisdiction over their own citizen, irrespective of the territory they are in or where they have committed an offense. And then finally, we have the passive personality principle, which is the right of a state to exercise jurisdiction over a person harming one's citizen. So these are some general principles that one can turn to when not sure about which legal regime could apply. But with regard to PillarDAO, we can make some interesting additional observations. The Pillar project was incorporated under the name Pillar Project AG as a limited company in Switzerland, and it is tasked with running all the commercial activities of the company. This LLC, the PPAG, in turn, is owned by the Pillar Project Foundation, which is also incorporated in Switzerland. In terms of corporate structure, we can also find Pillar Project Worldwide Limited, which is based in the UK. In essence, this UK branch acts as a service company, which is contracted with the Swiss LLC, PPAG, to conduct software development and ensure the adoption of the product itself. So, given this information, it can be assumed that the Pillar project and DAO would fall within the jurisdiction of Switzerland due to its foundation and the PPAG, as well as the UK. Moreover, given that PPAG as well as its foundation are incorporated within the EU EEA, EU law will be applicable if dealing with, or to some extent, at least when dealing within the EU, which is almost certainly the case if incorporated in Switzerland. So let's have a look at some financial regulation next. According to its own account, the Pillar project is committed to ensure compliance with existing financial regulations. According to the Pillar project itself, they follow the Swiss Financial Market Supervisory Authorities, in short FINMA, guidance with respect to the PLR utility tokens issued by them, and have also submitted a questionnaire to FINMA as required. Within the UK, the FCA is responsible for supervising AML and CTF for activities concerning crypto assets. PPWW, so the UK subsidiary, has registered with the FCA as required, but the authority has determined that the current activities of PPWW do not require them to register with the FCA itself. On an EU level, all custodian wallet providers and providers engaged in exchange services between virtual currencies and fiat currencies have to comply with the same AML KYC requirements as banks and other financial institutions. In practice, this means that Pillar will have to comply with requirements found in the EU AMLD5 directive, or just AMLD5. For instance, one requirement being, which came into force in January 2020, is that identity registration must be completed for all wallets that contain at least 150 euros per year. Moreover, given that the AMLD5 also applies to custodian wallet providers, internal policies, controls, or control procedures, including the drafting up of risk models or management practices, customer due diligence, and so on and so forth, will need to be recorded and kept in order to ensure compliance. So definitely a lot of stuff to consider there, especially for PillarDAO, if they want to stay out of trouble in terms of the AMLD5 requirements. Let's have a look at the corporate governance and structure next. So the Pillar Project Foundation can be regarded as the mother of the PPAG and the PPWW, so the Swiss LLC and the UK LLC, as it is responsible for managing the general business as well as the assets of the company. PPAG in turn acts as a sort of older brother as it exercises control over the PPWW. Increasingly, the idea is that the decision-making powers will be shifted to PillarDAO token holders. However, in my research, I have not been able to find a clear roadmap on or intention as to if or when the decision-making will be completely transferred to the DAO. Moreover, it has stayed a bit unclear to me whether the PillarDAO is incorporated as an independent corporate entity or whether there are plans to do so in the future once it runs autonomously. So that's one thing that will have to be considered. With regards to the key persons within the company, certain risks also might exist with regard to their fiduciary duties and responsibilities. There are a number of different duties that company directors need to fulfill in their roles, and directors, for example, can be held liable for certain offenses such as money laundering, or what's interesting in Swiss legislation, the failure to prevent the breach under various laws, which is quite broad if you ask me, but something to consider here. Let's move on to the European Commission's regulation of markets in crypto assets proposal. So although there is no official timeline available yet, it is to be expected that the MiCA proposal will most likely be implemented by 2024. While the contents of the regulation are not final, the proposal by the Commission does give a good sense of what to expect with regard to the regulation of crypto assets and their service providers on an EU level. Due to its legislative nature, MiCA will not have to be implemented into the national law of the member states and will take effect in the entire EU. In addition, any non-EU company wishing to do business in the EU in the field of crypto assets and which does not fall under any of the exemptions listed will have to abide by this regulation. So this is something to definitely keep an eye on. We are very sure that this will be coming up soon. Although PillarDAO is incorporated in Switzerland and the UK, it can be assumed that it falls within the scope of the MiCA regulation due to its business operations within the EU, as I mentioned before as well. Under the current proposal, PillarDAO would be regarded as a crypto asset service provider. Next slide. In short, CASP, as it is engaged in the custody and administration of crypto assets on behalf of third parties. Moreover, PillarDAO could be seen as issuing so-called utility tokens, which are issued with non-financial purposes to digitally provide access to an application, services, or resources available on DLT networks. As it is unlikely that any of the exemptions contained in the proposal would apply, for example, issuing assets regarded as financial instruments or falling under the scope of existing EU legislation, et cetera, et cetera. PillarDAO would certainly fall within the scope of the proposed regulation. With regard to PillarDAO, Section 5 of the proposal will likely be the most important one, as it concerns the authorization of CASPs. For instance, in order to provide crypto asset services, companies will need to receive prior authorization from competent member state governments. Additionally, a number of other regulatory requirements will have to be met by CASPs. For example, with regards to insurance coverage, training of staff, and so on. And depending on their business model, also capital or internal governance structure requirements may apply. Among other business operations, one could assume that PillarDAO could be seen as a custodian, wallet provider, and administrator of crypto assets. As a result, this would require PillarDAO to have a minimum capital of 125,000 euros. And in addition, PillarDAO would also be required to file quarterly reports on the crypto asset position they hold for each client and could be held liable by their customers for losses that result from hacks or malfunctions. So these are some of the things to consider with regards to the MiCA. Given all of this, when joining a DAO, the members should not only be aware of all the technical implications and the technical functioning of the DAO, but it is also really important that members understand the legal and regulatory risks. In certain cases, for example, under European law, DAOs are considered, so DAOs in general under European law are considered limited partnerships. So under certain circumstances, all members of a DAO, if the liability is not transferred anywhere else, can be jointly held liable. And by jointly, that means also a single person can be held liable for any breaches of regulations or existing laws. That's why it is so important. And also given future regulations such as the MiCA, it is really important that DAOs organize to develop and implement compliance roadmaps to achieve sustainable growth in line with any future regulation. And that essentially is also the key to success. And this is essentially where WACEO comes into the picture. WACEO is a nonprofit association which seeks to build networks of professionals and compliance-seeking DAOs and help them with any of these challenges with regard to regulation and legal challenges that might arise in the future. The whole purpose why we are doing these light audits is really to give just a short overview of some of the things that we noticed when looking at the DAO. These coverage are by no means extensive or exhaustive. I mean, these are light audits. So we really just cover some of the core parts that are immediately obvious. Of course, there could always be more underlying issues when looking at the DAO itself or when getting a little bit of a closer picture when conducting further investigations. That is it for today. Thank you so much for hanging around. As always, if you have any questions, please feel free to reach out to us. We're more than happy to help out. And in this case, until the next time, see you. Bye.